scramble in Louisiana to delay its May primaries is not an isolated administrative hiccup. It's a revealing moment in a broader shift in American political power. Coming immediately after a landmark ruling by the U.S. Supreme Court, the decision exposes how legal, political, and institutional forces are converging to reshape voting rights in a way that disproportionately protects white political dominance. At the center of this moment is the court's 6-3 ruling in Louisiana versus Callais, which sharply curtailed the reach of Section 2 of the Voting Rights Act of 1965. For decades, Section 2 functioned as one of the most effective legal tools for challenging racial discrimination in voting, particularly in the drawing of congressional districts. Its power lay in recognizing that discrimination is often systemic rather than explicit, embedded in maps, not statements. The court's conservative majority, led by Samuel Alito, reframed that understanding. The new standard requires plaintiffs to show strong evidence of intentional racial discrimination, a threshold that is extraordinarily difficult to meet in modern politics, where lawmakers rarely leave overtly racist records. In doing so, the court did not formally strike down Section 2, but it transformed it into something far weaker. This shift did not occur in a vacuum. It builds on a longer trajectory that includes Shelby County versus Holder, which eliminated federal pre-clearance requirements for jurisdictions with histories of racial discrimination. Together, these decisions represent a systemic narrowing of federal oversight in voting rights, one that critics argue opens the door to policies that maintain racial disparities in political power, while avoiding explicit racial language. The immediate aftermath has been telling. Louisiana officials, including Governor Jeff Landry and Attorney General Liz Muriel, moved quickly to halt upcoming primaries, arguing that the state's current maps can no longer be used. At the same time, they're working to redraw those maps under the court's new framework. Other southern states are signaling similar intentions, with some already preparing special legislative sessions to revise district boundaries before upcoming elections. Redistricting is typically a once-a-decade process tied to the census, but recent years has seen an acceleration of mid-cycle map changes, often driven by partisan and racist incentives. Encouraged by Donald Trump, who's openly supported redrawing maps to benefit Republicans, states have increasingly treated district lines as flexible political tools rather than stable democratic structures. What has changed now is the legal landscape. With Section 2 weakened, states have greater freedom to redraw districts in ways that may dilute minority voting strength, provided they can frame those decisions in non-racial terms, such as partisanship or traditional redistricting principles. In regions where race and party are closely aligned, particularly in the South, that distinction becomes largely semantic. This is where the accusation of protecting white political power emerges most forcefully. By insisting on a form of race neutrality, the Supreme Court is ignoring the historical and structural realities that shape American elections. Black voters, for example, are often geographically dispersed or strategically packed into a small number of districts, limiting their broader influence. Efforts to correct this imbalance have historically required some consideration of race. The court's new standard makes such corrections far more difficult. Plaintiffs must now propose alternative maps that do not take race into account, while also satisfying political and geographic criteria set by the state. In practice, this creates a paradox. How do you prove racial discrimination in a system where acknowledging race is itself restricted? In dissent, Justice Eleanor Kagan argued that the ruling effectively dismantles the Voting Rights Act's remaining force. She pointed out that the decision allows states to weaken minority voting power without facing meaningful legal consequences, so long as they avoid explicit racial justifications. Her critique highlights a central tension in the ruling, the gap between formal legal standards and lived political realities. Civil rights advocates have echoed this concern. Derek Johnson of the NAACP condemned the decision as a betrayal of both black voters and the broader democratic system. Former President Barack Obama warned that it enables states to carry out racial gerrymandering under the guise of partisan strategy, a distinction that may be legally significant but practically meaningless. The Louisiana case itself illustrates the stakes. After the 2020 census, the state drew a map with only one majority black district, despite black residents making up roughly a third of the population. A federal court ordered the creation of a second majority black district, recognizing that the original map diluted black voting power. Louisiana complied, but the revised map was challenged by non-black voters and ultimately became the basis for this Supreme Court ruling. The result is a legal environment where efforts to ensure minority representation can themselves be struck down as unconstitutional, while maps that reduce that representation may stand if justified on other grounds. This asymmetry is what many critics identify as a structural protection of existing power hierarchies, particularly in states where white voters remain the majority. The broader implications are significant. Redistricting shapes not just elections, but policy outcomes, legislative priorities, and the distribution of political influence. By making it harder to challenge discriminatory maps, the court's decision may entrench patterns of representation that favor white groups over black voters. What is clear is that the combination of judicial decisions, political strategies, and institutional changes are reshaping the landscape of American democracy. The tools that once allowed courts to intervene in cases of racial inequality are being narrowed, while the opportunities for states to act with impunity are expanding. In that context, Louisiana's delayed primaries are more than a logistical adjustment. They are an early signal of how quickly states may move to take advantage of the new legal framework and how the balance of political power in the United States continues to shift into the hands of white supremacists. I'm Anthony Davis. You can find me on the 5 Minute News YouTube channel and podcast, on Wednesdays co-hosting Uncovered, on Global AF, on Legal AF, and on Sundays on The Weekend Show with MeidasTouch.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.